to the end of the session so we can have a nice solid presentation. So Colleen, many or all of you have heard of Colleen. She's quite well known in the country, and particularly on these topics. She's an emeritus professor at Southern Cross University and the principal director of Cartwright Consulting Australia. So, which is why I say Colleen would have a lot to know about in terms of program evaluation, because she's been a consultant for much of her career. She has extensive teaching and research experience in ageing, ethics, and medical decisions at the end of life. At national and international level. And today she's here to talk to us about advanced care planning. What is and not euthanasia, what constitutes capacity to consent to things like advanced care planning, as well as artificial nutrition and hydration. So a whole batch of critically important topics about the care of people at end of life. So really, really pleased to have Colleen here. Great to have this session running. So Colleen, over to you. Thank you.
So next, we're obviously not on.
I can hear somebody speaking, Matthew. I don't know where it's coming from.
Yeah, I'm just looking to see who I haven't muted.
Do we need to mute?
Probably Meredith. That was it. That
Right.
was the Newcastle node just starting up.
Okay, thanks, Matthew. I thought I was hearing things, and that's always a possibility too. The title, Best Death Possible, that I chose for this, and how can we help clients achieve that? Now, I use the word clients here, clients, residents, patients, whatever terminology you use. But there's a little book that was written by Sarah Winch from the University of Queensland, and it's called Best Death Possible, a guide to dying in Australia, that I'd really recommend. And it's a little one that is really helpful for the people that we just mentioned, clients, residents, families, whatever. So what I'm going to do is go through some of the issues without actually answering the question at this stage, how can we help clients achieve that, except to say that we help them by understanding these issues, and then we can discuss at the end what specific things we might be able to do. So I'm just going to say next, and Susan will push the button to change the screen. So next.
And Colleen, while we're waiting for the screen to change, one thing I forgot to mention to everybody is I'm recording the session so that we can load it up on the website. So if you've got something you don't want to be seen saying, then don't say it, because we want to share this later on.
That's good advice. Okay, so the context for what we're talking about today is that better living conditions and healthcare have led to increased longevity. You may know that.
It's coming through, but we're not hearing it out the speakers.
Sorry, Matthew. Meredith's coming through again.
Okay, so Meredith, is there an issue? You've maybe got your sound turned off at that site if you can't hear it through the speakers. No, I'll mute the node again and we'll see how they go. Keep going, Colleen.
Okay, as I said, we have increased longevity, and you may know that in the last census we had just on 4,000 people in Australia over 100, many of them still living at home well and happily. Now, if you listen to the shock jocks, you'd think an ageing population was a terrible thing, but in fact it's a success story. Think about what the alternative is. Do we want to go back to where the average life expectancy at the turn of the 19th, 20th century was 50? So we should be celebrating longevity. And the current furor around the cost of an ageing population that our current government treasurer has been carrying on about, saying, need to pass the health budget because it's, people born today could possibly live to 150. Well, Professor Bob Birrell recently did a study which demonstrated that the increasing healthcare costs are not due to the ageing population, not due to demographic factors at all. And if you look at the interventions that people in acute care are subjected to, and I say subjected in many cases because frequently it's unwanted and unwarranted treatment, but the older the people are, the less the high-tech invasive treatments they are likely to receive, which are the costly ones. Okay, so in addition to better living conditions, rapid technological development has allowed people who would previously have died to be kept alive for long periods of time, often through the use of such things as ventilators and feeding tubes. But these successes have led to practical, legal and ethical issues, in particular around end-of-life care and extending the dying process. Next. A lot of my research demonstrated there are great fears in the general community about the end stage of life. I've had cases reported of loved ones left hooked up to machines until the very end. We couldn't even get close enough to give him a hug and say goodbye. Another woman said Mum always said she wouldn't want to be resuscitated if her heart stopped, but they wouldn't listen. Now, this next one I'm going to come back to later, but just think about it. This was a man in his late 80s who had multiple problems, and he decided he'd had enough. He had capacity and he had decided that he wasn't going to eat anymore. His wife said, first of all, he was stubborn when he was in hospital. He wouldn't eat. He was just starving himself. They couldn't get him to eat, so they had to force feed him. They put a tube down his nose and then they had to tie him in the bed because he kept pulling it out. He just didn't want it. Well, if he just didn't want it, he just didn't have to have it. And I'll explain that more later. But let me just say, had his wife known the law, she could have taken action at that point. Next. Another man felt that the specialist just couldn't accept defeat. And because of that specialist, he said they were still trying to cure her, but it wasn't any point. They were doing everything. Everyone was making out this was going to be the answer when they knew damn well it wasn't. So what are we left with? We're left with angry and bitter carers who feel that they failed the person they loved because they weren't able to ensure that the death that that person experienced was what they had wanted. And if I don't refer to it again before the end of this bit, remind me to talk to you about patient advocacy and some stories around that, because we all have to be patient advocates at the end of life. Another woman told me her mother said that the medical staff were running through her room like a gravy train. She didn't know most of the time what they were there for or what they were doing. They usually just said something like, "Now we're just taking you down to test you for whatever." They never asked her permission. Now, just because you're in hospital or residential care does not mean that you've given up your right to informed consent. You still should be told what's being proposed. You still should be told what the alternatives are to that. And you absolutely have the right to say yes or no to what's being proposed. If I say to a doctor or a nurse, "Don't touch me," and they do, even to save my life, I can have them for assault under the common law in every state and territory of Australia and under the criminal codes of those states and territories that have a criminal code. And that relates back to the one I just talked about before with the tube feeding. Next. So a lot of the problems that I've just outlined stem from confusion over what is and what is not euthanasia. And that leads to inadequate pain management. It leads to the inappropriate use of medical technology. It leads to fear among health professionals about the legal consequences of care provision. It leads to poor doctor-patient communication, and it leads to disillusioned patients, families, and carers. Next. Next. Some commonly held beliefs are that euthanasia includes giving increasing amounts of needed pain relief, which may also have the effect of shortening the person's life, or respecting a patient's right to refuse further treatment, or withholding or withdrawing life support systems that have ceased to be effective or that will provide no real benefit to the patient from the patient's perspective. None of these is euthanasia, and I'll explain that next. The World Medical Association defines euthanasia as the deliberate ending of a person's life at his or her request using drugs to accelerate death. In studies my colleagues and I have done in Australia and in Europe, we think that what describes it best is that euthanasia is a deliberate act intended, and that's the most important word in the definition, intended to cause the death of the patient at that patient's request for what he or she sees as being in his or her best interest. So it's active, it's voluntary, it's euthanasia in its original meaning of the word, of a good or peaceful death. And I put to you that that is the only way the term euthanasia should be used. You hear lots of other terms like passive euthanasia and involuntary euthanasia and non-voluntary. Please don't use them. I mean, in some cases, those words are just fudging for, it could even be as severe as murder. But that is the what I would put to you is the best definition of euthanasia. Next. So let's look at some of the things that are not. Giving pain relief, which may also shorten the patient's life, is often referred to as the doctrine of double effect, where the primary intention is to relieve pain. A foreseen secondary unintentional effect may be, usually isn't, but may be the hastening of the person's death by a few hours or days. A lot of my palliative care colleagues get very cross and say you don't even have to use the term the doctrine of double effect, because if we give the right combination of drugs in the right doses at the right time intervals, we won't hasten the person's death. My response, out there in the wider community away from palliative care, there are many, many people who believe that it does. Giving adequate pain relief, which hastens death, they believe is, giving adequate pain relief, they believe hastens death. So I think we should continue to use the term until we can ensure, if we ever can, that people are not dying in pain. And the doctrine of double effect is in fact accepted by most religious and medical groups, including those who strongly oppose euthanasia. For example, the Catholic Church accepts the doctrine of double effect because the first person to use the term was St. Thomas Aquinas. And Aquinas said, if you must achieve a good end, in this case relief of pain, and the only way you can do that is to also run the risk of a foreseen but unintended secondary consequence, i.e. hastening death by a few hours or days, you must still achieve the good end. There is no excuse for leaving a terminally ill person in pain. Bottom line, end of story. And you know the irony of all this? Not giving adequate pain relief when it's needed may shorten life. You leave a patient in severe pain, they can suffer life-threatening cramps, respiratory problems. So you get these numbskulls who say, oh, we can't give them more pain relief, we might hasten their death, so we'll leave them in agony and hasten their death. Oh, duh. Next. You can't tell I get upset about that one, can you? Okay. Respecting a patient's right to refuse further treatment is a legal and moral right, which I've just already told you, possessed by every competent person. It's also the right of someone who isn't competent now, but who wrote down their wishes in an advance directive, or appointed a substitute decision maker and told that person, if I'm in this condition or that condition, don't let them do anything else apart from keeping me comfortable. Now, one of the things we've got to be really careful of here is that sometimes people fear that if they refuse certain treatment, they'll just be abandoned. And there are healthcare providers who make them feel that way. But saying I don't want specific treatment doesn't mean I don't want care. Next. And withholding or withdrawing futile life support systems used to be called passive euthanasia. And as I said before, please don't use that term. It is unhelpful. It can lead to the inappropriate continued use of invasive technology, because even the word euthanasia, people say, oh, we can't do that. And you know, often the futile life support systems are not prolonging life. They are merely prolonging the dying process. If I'm on my dying trajectory and you interrupt that process by putting in a ventilator or a feeding tube or a dialysis machine or some other form of technology, and after a time you realise you can't return me to any sort of quality of life, all you have done is put a roadblock in my dying. And if you remove that impediment to my dying that you put in the first place and allow my natural dying to continue, keeping me comfortable in the process, that has nothing whatsoever to do with euthanasia. Removal of futile treatment is good medical practice. There is one little glitch. There's no definition of futility in the law, but it's generally agreed to be when burden outweighs benefit. But burden and benefit should only be from the patient's viewpoint or the viewpoint of the person who knows them best. I've had doctors say to me, oh, I could keep them going for another week. Really? And you think they'd thank you for it in the condition they're in? Burden and benefit is not from the viewpoint of the service provider. The other thing to think about, though, is that someone may, in fact, if they have capacity, choose to tolerate a level of burden that they might not otherwise, if the benefit is that someone who's on their way home from overseas or whatever will get there in time for them to say goodbye. So it's whatever the patient themselves says. Next. In research my colleagues and I've done, and this research is going back a little way, but I've done more recent work in New South Wales and found something similar, very similar responses. We asked people, and these were very big studies, the 3 I have up there, the 2 in Queensland and the 1 in the Northern Territory. If you were terminally ill, what do you think would cause you the most distress? In every study we did, loss of mental faculties came in first and loss of control came in second. In the first study, we had extreme pain. You can see Q1, extreme pain down near the bottom, came in at number 3. And then the research team said, why have we got extreme pain on this list? If someone's in extreme pain, they should sue their doctor. So we changed it for the next 2 studies to simply physical pain. And in the second one, it dropped down to number 6 in the ranking. In the third one, it dropped down to number 8 in the ranking. And the more items we added in, the further down it went. In every study we did, death itself came in last. People were not afraid of dying. They were afraid of loss of mental faculties, control, independence, dignity, being a burden on families. These things were of much more concern to people than death itself. Whenever I look at this slide, it reminds me of Woody Allen. You know, Woody Allen said, I'm not afraid of dying, I just don't want to be there when it happens. Well, I do want to be there when it happens, but I want it to be right. People do tell me that my work in this area has all been self-interest. I wouldn't quite say that. Next. So what can we do? Well, advanced care planning helps to address fears and concerns. Now, throughout Australia, terminology is different, the law is different, the substitute decision makers are different. I have tried to be generic where I can, but I'm only going to mention financial mechanisms here at the beginning and say to you, if someone has enduring power of attorney, depending on which state or territory you live in, it might be that enduring power of attorney applies to both financial and healthcare decisions. But you need to check the document and make sure what authority a person has for making someone's decisions. Enduring power of attorney, for example, in New South Wales applies only to finances. In Queensland, it could be either. So we're going to mostly talk about personal and healthcare mechanisms, advance directives, however known in your state or territory, patient-appointed substitute decision maker, and a default decision maker. Next. So all states and territories have legislation allowing patient-appointed substitute decision makers. It's interesting that the last state, territory, in fact, the last state or territory to pass that legislation was the Northern Territory. For quite a long time, they still were not allowing people to appoint their own substitute decision makers. And I remember when I was up there a couple of years back and I spoke to an Aboriginal woman who'd been caring for her mum for a long time. When her mother lost capacity, the court appointed someone entirely different, even though this woman had been caring very well for her mother. Well, now the NT's in line with everyone else. So all states and territories have legislation allowing patient-appointed substitute decision makers, and they have all agreed that appointments made in other states and territories will be recognised. So if you've appointed someone in Queensland and you're down in Victoria, that appointment would be recognised. All states except New South Wales and Tasmania also have statute law for making advanced care directives legally binding. In New South Wales and Tasmania, they are binding under the common law. Now, that's really important to note because I had an email just 2 days ago from someone working in a renal unit in a hospital in New South Wales, where other staff in the unit were saying to him that advanced directives in New South Wales are not legally binding. They absolutely are legally binding. They always have been under the common law, and it was the reason why the Working Party in New South Wales decided not to put statute law in place. They said it's unnecessary because they're already binding under the common law. However, I think that was a mistake because being the only 2 states that don't have it, doctors and solicitors for a long time were telling people in those states that advanced directives were not legally binding. Well, we used to rely on UK common law for anything we didn't have case evidence for. And the case I used to depend on there was Ray C., a man with a gangrenous leg, who the doctors wanted to amputate. He said, I'd rather die with 2 legs than live with 1. They said, no, we'll wait until you lose capacity and we'll take it. He said, no, you won't, and went to the court. And the court in the UK said, confirmed his right, the right of a competent person to refuse in advance what will happen to them when they're no longer competent. But we hadn't had a common law case in Australia, which was tricky at that time, because we, as I said, we're no longer bound by the UK common law. Fortunately, as luck or supreme being or anyone you want to think of would have it, in 2009, the first common law case in Australia happened in the New South Wales Supreme Court. A man was in Taree Hospital, very unwell. He was admitted and lost capacity and went into renal failure and was put on dialysis. Very shortly thereafter, one of his friends arrived, and his friend had been appointed enduring guardian, which is the substitute decision maker term in New South Wales, but also had with him a handwritten, unsigned, as it turned out, by anybody, advance directive stating that he and the substitute decision maker were both Jehovah's Witnesses, and not only did he not want a blood transfusion, he did not want a dialysis. The local health district, the local health district did a very smart thing, didn't oppose it, simply applied to the Supreme Court for a decision to take the man, to say whether or not they could take the man off dialysis knowing he would die. And the judge gave that decision immediately, reserved his judgment for a couple of weeks, and I was holding my breath thinking, don't say it was because his enduring guardian said so, although the enduring guardian had the right to say so, because what we needed was a common law case about the advance directive. And the judgment, first the judge tested forensically the document to prove that it was the man's handwriting. And then in the judgment, he goes through all of the ways a person with capacity can make their decisions known for loss of capacity. And it comes down to, as far as the advance directive, you can write it on the back of an envelope. And if there's evidence you've written and no evidence you've changed your mind, it holds. That's called the Hunter decision. And if anyone would like a copy of that, let me know. Next. So, patient-appointed substitute decision makers. And this is pretty standard. There will be some variations through the states and territories, but I can't give you all that. If you want any specific information about your state or territory, you can email me later. So a competent person over 18 can appoint a substitute decision maker to make personal and lifestyle decisions or decisions about medical or dental treatment on their behalf in case they lose the capacity to make their own. The person you appoint has to be at least 18 and is usually a trusted relative or friend. You can't appoint your GP, you can't appoint the community nurse, you can't appoint the person that the family are calling to come in and look after, or paying to come in and look after you. Can't appoint someone at the res care facility who's looking after you. And you can't appoint a relative of one of those either. Now, the interesting thing for me is that when I do this sort of a presentation out in, say, Western Queensland or New South Wales, they say, well, that wipes out the community. There's nobody left. At that point, I tell them to contact the public guardian. Next. And you can appoint more than one, and you can say how they're to make their decisions. When I was doing mine, which, by the way, I hope you have all done, because advanced care planning is not just for older people. And if you haven't done yours, how are you going to know how to talk to your clients, residents, patients about what it feels like or what to think about? Anyone could be injured in a car accident or on the sporting field. If I was in the room with you at this stage, I'd be asking you to put your hand up and tell me who's appointed a substitute decision maker and who's written their advance directive. But I can't do that, so I'll just have to assume you've all done it because you're all smart people. Okay. When I was doing mine, I contacted my son and I said, Steve, am I right in thinking you'd be happy to have my enduring power of attorney for finances, but you would prefer that Kim has my enduring guardianship for healthcare? And he said, oh, absolutely, Mum, because she'll do as you tell her and I won't. I went, oh, great, wonderful. He said, no, I know you. You'd say if I'm in that condition, don't let them do any more tests or operations. But I'd want to bring in every specialist that existed and keep you going to the last gasp. But Kim will do as you tell her. So I phoned my daughter and I said, is this okay by you? And she said, oh, of course it is, Mum, but isn't it typical? The boys get to look after the money and the girls get to do the caring. However, because you can appoint more than one and you can say how they're to make their decisions, For my finances, Steve's first, Kim's second, my close friend Barb's third. For my healthcare, Kim's first, Steve's second, Barb third. And I've put serially in the order listed above. So that's the order in which they make their decisions. And I've told Steve if Kim's away overseas or something and a decision's needed and he has to make the decision, if he makes the wrong one, I'll come back and haunt him. It's pretty simple, really, isn't it? Okay, the person you appoint has to agree to the appointment, should understand your wishes and be prepared to carry them out. The appointment has to be in writing in the approved form, and the form has to be signed by the person themselves, by the person you've appointed, by the person you've appointed, by a doctor and by a witness. Now, the doctor doesn't have to sign, the substitute decision-making form. That's a mistake on the slide. I apologise. That should be for the advance directive, but it has to be witnessed. Okay, next. So now we'll look at advance directives. An advance care directive is a written, legally binding document which allows a person to make their wishes for future healthcare known. It extends the current right of a competent person to refuse treatment to a future time when they may not be competent. Now, just for Victorians, you're the only state or territory at the moment that doesn't have a true advance directive. The legal document there at the moment is called a refusal of treatment certificate, and it applies only to a current illness, which doesn't have to be terminal. So you can refuse treatment for a current illness. You can't anticipate the future. If I have a car accident, if I have a stroke, if I have a heart attack. But there is an inquiry happening in Victoria as we speak that is looking at all the end-of-life issues. And I've made a submission to that inquiry about this very point. And the Respecting Patient Choices program that Bill Sylvester runs down there and out of the Austin Hospital originally, they have been using an anticipatory directive for quite a long time. My understanding is it hasn't yet been tested, for example, with a common law case, but perhaps the legislation will change in time that won't be needed. Now, advance directives are not a form of euthanasia. An advance directive only allows actions which a person could legally consent to for themselves if they were competent to speak. I mean, obviously, someone could write in their advance directive that they want euthanasia, but where the rest of the directive would be legally binding, that wouldn't be. And as with the substitute decision maker, it only comes into effect when the person making it loses decision-making capacity. So making it now while you're young and fit and healthy doesn't mean someone can start operating on that right now. And the same with your substitute decision maker. Neither of them apply unless you have lost capacity, and we'll talk more about capacity. That's different to the financial one. You might be an older person who's absolutely fed up with trying to manage their own affairs, and you might have a daughter who's a whiz-bang accountant, and you might want to appoint that person to start managing your finances right now, and you can do that. But the person is still your agent. They can't just go ahead and do anything they want. They have to keep a record of your property and their property, and they have to keep them separate. They have to keep a record of what they do. And if you don't want them to do something, legally they can't. The problem is there's no actual oversight, legal oversight, and someone would have to report them if they're misusing your funds. But advance directives and substitute decision makers for healthcare only happen when you've lost capacity. Next. So let's look at that. So when does a person have capacity? To appoint someone, to write a directive, or to make their own decisions? The legislation throughout Australia is based on the United Nations principle of presumption of capacity. I don't have to prove to you that I'm competent. I'm competent unless you can prove I'm not. So the onus of proof is not on me, it's on you. And if you are uncertain, particularly in, say, a res care situation or someone who's maybe come into hospital unconscious from a car accident or something, and you're not sure if they are actually competent, then the person has to understand the nature and the effect of the decisions to be made. I won't go through the case studies now because we might run out of time, but you can ask me later if we have time. But just to say that the person doesn't have to tell you in medical terms. They simply have to know what it is that they're talking about. And the same with being able to communicate the decision. I've assisted someone to complete an advance directive who was, they thought he was tetraplegic after a car accident, but he recovered the ability to nod and shake his head. And that was sufficient. We were able to, with the doctor, the nurse, his wife, his mother and me, help the person complete an advance directive. Next. Now, incapacity is not ignorance. If you haven't been given enough information, that says nothing about your capacity. Might say something about the person giving it to you. It's not eccentricity, cultural diversity, or having different ethical views. It's not communication failure. I wish you were all in the room, because at this point I usually ask people to put up their hands and tell me anyone who's never made a bad decision. Think about that. Any of you never made a bad decision? I've made some doozies in my day. Don't think I lack capacity at the time, but I wouldn't put money on it. But making what someone else thinks is a bad decision is no evidence of incapacity. And neither is disagreeing with your healthcare provider. In fact, that could be the opposite. And please beware the mini mental state exam. It is not a capacity assessment tool, even though it's used that way all the time. There's really good evidence it should not be used for older people or people with low education. So who does it get used for? Older people and people with low education. I once asked one of my research assistants if I could administer it to her, and she came in borderline competent. She wasn't, of course. She was a woman with not a very high education, but she used to come in and help me with mail-outs and all sorts of things. Very sensible person. I would have left my centre in her charge any time. I asked a medical student to take 7 from 100 and keep taking 7 from the results till he told me to stop, till I told him to stop, and he said, not without my calculator. I asked someone else to spell world backwards. She said, I'm a rotten speller. I probably couldn't even spell it forwards. On the basis of such stupid questions, people are deprived of their rights to make their own decisions, which is unethical. I know you have to use it sometimes if you need a script for Aricept, but it is not a capacity assessment instrument. It is a screener and should never be used alone. Next. So in a lot of the research we've done, we ask people if what you think would stop someone making an advance directive. And you can see in the heading there, CTY means community members that we asked, and HPs means health professionals. Don't worry about the last column for now. Now, in this particular study, not knowing enough about them, both groups put that at the top. But you can see that the health professionals thought it was a bigger issue than the community did. It's not rocket science. You can help any of your clients, residents, patients to do it, and it's not that difficult. But the next 3 are interesting. 63% of the health professionals said people would prefer to leave the decision to the doctor. No, we wouldn't, said the community. And 37% did, but the other 63% did not want to leave the decision to the doctor. The 37% were majority older people, the very oldest in the group. 75% of health professionals said people don't like to think about end-of-life issues. Yes, we do, said the community. Only 33% of them didn't, and again, the very oldest. And 69% of health professionals said people would prefer to leave the decision to the family. And basically the community said, rubbish, we don't want to leave the decision to the family. And folks, look out for the baby boomers when they come up to being in their 70s and 80s. They're not going to let anybody tell them what to do. Next. So what are some of the benefits of advance directives? You remember that list I put up about what people fear most. And on top of the list was loss of mental faculties. Advance directives come into effect when you've lost your mental faculties. The second one was loss of control. This gives control back to the patients. It ensures the patient's wishes are known. It's the patient's own words. It also assists healthcare providers with decision making. When we first got the legislation through in Queensland, I had an intensive care specialist from Townsville contact us and say, thank you for these advance directives. At least now I have some idea of what my patients might want. They relieve family stress at times of trauma. Now, think about that. Times of stress and trauma can bring out both the best and the worst in families. And if there has been no planning done and somebody's got to say switch off the machine, then every wedding and funeral from then on, when somebody's had a few jars, you killed my mother. Well, if you can say, all I'm doing is making sure mum's wishes are respected, and here they are. You can help families from fracturing. The last one, giving security in relation to future events. I think it's a good way to introduce this topic to your residents, clients, patients, which I do when I'm talking to people. As I explain to people, I hope my house doesn't burn down, but I have an insurance policy against that. I hope I don't have a car accident. I have an insurance policy against that as well. I hope I'll never be terminally ill and I can't speak for myself. I've got an insurance policy against that too. I've appointed a substitute decision maker and I've empowered that person by giving them a copy of my advance directive. Now, that can also help to address the fear some people have. Oh, if I do that, maybe I'll make it happen. I mean, superstitious, but ask them if they have an insurance policy for their car. Next. Now, where should you keep an advance directive? Well, there should be a copy in your GP file, and the GP, I believe, is the most appropriate person to help people with this. A lot of GPs find that it's a little bit time consuming, but for any patient, they're probably only ever going to have to do it once or at the most twice, and maybe with a copy in the file, check on the yearly checkup or whatever, are you still thinking the same way? But certainly a copy with your substitute decision maker, a copy accessible at home. One old lady that I helped with her advance directive, she was so determined no one was going to miss it, she had it in a plastic sleeve, blue tacked onto the front of the fridge. And if someone goes into hospital or res care or even in community care, a copy should be placed in the person's record and be available when needed. Next. Now, this bit is really, 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 really important because a lot of people still don't know a lot about advanced care planning and haven't written an advance directive or appointed someone to make their decisions. I used to think that the advance directive was the most important bit, but I've come around to thinking that if you can at least get someone to appoint a substitute decision maker, that's a really good start. And the reason I've come around like that is because lots and lots of older people now have enduring power of attorney for their finances. And it isn't a big step to convince them to appoint someone to make their healthcare decisions. But to actually write the advance directive can be a little more challenging. Once they've appointed the substitute decision maker, I usually suggest to them that to help that person and make sure the other family members can't challenge them, they should write the advance directive. But what if you haven't done any of those? Well, I'm using New South Wales terminology here, but you need to look at what the correct terminology is in your state or territory. Throughout Australia, if you haven't appointed someone, it is not next of kin. It is not automatically next of kin who gets to make the decision. In all the legislation, there is a specified order of authority. And for substitute decision makers, as I said, every state and territory has legislation. In New South Wales, it's called person responsible. And the list is similar in most states and territories, and that's the first readily available of a spouse, including de facto or same-sex partner, provided the relationship is close and continuing. Actually, that includes the spouse, provided the relationship is close and continuing. If there isn't a spouse, and lots of older people don't have a partner or spouse, then it moves to non-professional carer. And that's often a younger daughter or daughter-in-law. And as I said, because it's not next of kin, sometimes we'll get these big strapping lads come in and say, oh, mum's next of kin, so I get to make her decisions. Sorry, Sonny Jim, it's your sister that's been doing all the work and she gets to make the decision. Because the non-professional carer is much more likely to know what the person would want than necessarily the next of kin. There was a case in the New South Wales Supreme Guardianship Tribunal where a woman had 3 children whom she hardly ever saw. And she had a next door neighbour who used to come in every morning and help her out of bed and take her to the doctor and do her washing. And that when the woman lost capacity and the children started making decisions that the neighbour knew she wouldn't want, the neighbour applied to the Guardianship Tribunal and she was deemed to be carer under the meaning of the Act. The Act specifies the person who has the day-to-day care of. It's not, by the way, someone in a res care facility. When we say a non-professional carer, someone receiving a carer's pension qualifies as a non-professional carer. If a person is in a residential aged care facility, the staff member at the facility doesn't qualify. Usually it would be whoever was the carer before the person went into the facility, or whoever visits them most and pays the bills, etc. Next. Okay, now artificial nutrition and hydration is an issue I wanted to raise with you because it's a tricky one, and one that you're going to need great skills to help families understand. When a person enters their dying, so they're in the terminal phase of their illness, or when they have advanced dementia, they often lose their swallowing reflex. And it's a normal part of the dying process. And they generally should not receive artificial nutrition or hydration through a PEG tube or nasogastric tube. Sometimes for someone in that condition, a PEG tube will be inserted if it's the only way that comforting or anti-fitting medication or whatever can be delivered. If the person can't swallow it and perhaps their veins are not good or whatever, sometimes there is a reason for that. But a PEG, a percutaneous endoscopic gastrostomy, which is a feeding tube inserted directly into the patient's stomach under anaesthetic, should not be used as a general rule for people in that situation. Finucane did a 30-year Medline search of all trials of PEG feeding, and he couldn't find even one study that demonstrated any of the claimed benefits of PEG feeding for people with advanced dementia. It didn't improve skin integrity, it didn't prevent aspiration pneumonia, it didn't improve quality of life. It did cause scarring and weight gain and aspiration pneumonia and other things. But the problem is, not only can it increase suffering, as I've just said, it can also prevent a peaceful death, because when someone is approaching the end stage of their life, the human organism is designed to recognise when death is approaching and to release endorphins that act like a natural analgesic. So you'll see someone who's been terminally restless, and then towards the very end they become calm and euphoric. And that's because the body has released the endorphins. But if you continue to artificially feed and hydrate someone in that situation, as I said, not only can you increase their suffering, you can deprive them of a peaceful death, because the body doesn't get the signal that death is approaching and doesn't release the endorphins. And they do not suffer hunger and thirst if they've entered their dying, and that's what you have difficulty helping families understand. I've had people say, oh, if only we could get him to eat something, you'll get his strength back. No, he wouldn't, darling, he's dying. Except you wouldn't say it quite like that, would you? Okay, and with terminal sedation, about 3 to 5% of terminally ill patients, and usually those with neuropathic pain, need terminal sedation, that is sedative drugs to induce unconsciousness in order to relieve suffering when other attempts at relief have failed. And that includes withholding or withdrawing artificial nutrition and hydration. Next. So just quickly back to PEG feeding, a Victorian case some years ago, a woman who had a PEG inserted 8 years previously while she was still somewhat mobile. For the last 3 years, she's been in a fetal position in a nursing home, and all nutrition hydration medication was inserted through the PEG. She and her husband had agreed that neither would allow the other to linger in such a condition, and her husband applied to be appointed her guardian. But the Supreme Court decided that the public advocate would be appointed instead, and the public advocate applied for the removal of the PEG, and that permission was granted. And artificial nutrition and hydration was considered not to be palliative care. Next. Another case, this one is, I think probably we'll skip this one, please, Sue. Go to on, keep going. And again. Right. So the benefits of PEG feeding I've just been through with you. And the interesting thing, and the only other thing there that I haven't already told you, is that most recent studies have found evidence that the body produces the endorphins that I spoke about, even in people who are unconscious or have dementia. So you can prevent a peaceful death even in those conditions. Next. My colleagues and I did a study in Queensland quite a few years ago now, but unfortunately this has changed, which I'm pleased to say. But at that time we found that there were a lot of people in residential care with PEGs inserted, and 91% of the directors of nursing in those facilities said it was important to have guidelines about withdrawing, withholding life-sustaining treatment, but less than 5% had such guidelines. And there was concern about the lack of understanding of the needs of older people in the acute setting. Next. And the reasons for PEG use, and I've put this in just in case any of this is still happening where any of you are, that it was easier and better than nasogastric for residents and staff, that the technology was known and available. There was a lack of understanding of care of the older person in acute care settings. Now, I know that is still the case. And some speech therapists and dietitians that I speak to now think that the loss of the swallowing reflex is a trigger for a PEG, and it isn't. Wanting to prolong life at all costs and not considering the long-term consequences or quality of life was another reason for using it. Families wanting to prolong life and deny death. The medico-legal fear of litigation, and better and easier acute care management than one-on-one feeding of a person who's very slow to feed. Next. And negative comments regarding use of PEGs. This came from the nurses. Kept her hydrated and with enough nutrition so she can lie semi-comatose in bed and be a guilty burden to her family. Lengthened the lifespan even though the resident is almost in a vegetative state. Has occasional sight irritation, vomiting and constipation. Poor quality of life, constipation and depression. No social interaction at meal times. Deprived of the pleasurable tastes and smell sensations related to food. Another one, for 10 years this woman had been in a neurovegetative state, but her husband was insisting on treatment. Now, let me say to you, it is not okay to do something negative to a patient, client, resident just because their family asks you to. Your primary responsibility is to that person, not to the family. Of course, you try to take the family along with you, but there reaches a point where you have to say, I will not harm my patient, client, resident to make their family happy. And the next one, the husband in this case had requested that she didn't have a PEG, and it was put in anyway. I thought it was very poignant that the nurse said he still visits 3 times a week. Next. There were some positive ones, giving nutrition, hydration safely, and in this case the resident is demonstrating a sense of well-being. Improved nutrition and skin integrity, more alert and can take pleasure from family visits. Better medication effect. Now, the better medication effect I can endorse. And this one where the person appears to enjoy his life. You need to look at each case individually. Next. The Hastings Centre, which is a very well-respected centre for ethics, says that no one should in the modern world have to live longer in the advanced stages of dementia than he or she would have done in the pre-technological era. Just because you have dementia doesn't mean you have to use it. There's an old saying that if you have a hammer, everything looks like a nail. Just because you have technology doesn't mean you have to use it. And the more advanced the damage of dementia, the more legitimate it is to overturn the usual bias in favour of treatment. And whoever is making the decision has as strong an obligation to prevent a painful and degrading death as to promote health and life. Next. So, other ethical issues regarding life-sustaining medical treatment. The rights of vulnerable people. Who will speak for people who've lost the capacity to speak for themselves? You need to be asking yourself if life-sustaining treatment is being used where you are. Is it sustaining life or is it prolonging dying? And quality of life, what contributes to that? Often it includes social interactions, including shared meals. We do have to take into account the use of community resources. A lot of people think, oh, we shouldn't be taking that into account. We should provide whatever is needed. Yes, but what about providing unwanted and unwarranted treatment? That's the benefit of advanced care planning. And advanced care plan directives are legally binding. The order of authority, by the way, if someone has written an advanced directive and it meets the current situation, it comes first. If there is no advanced directive and there's an appointed substitute decision maker, that comes second. And if there's none of those, then we go to the order of authority in each state or territory. But just recently I was told of the case of a woman who didn't want to have a heart operation, was talked into it eventually. She arrested on the way to theatre and was revived, and the operation went ahead. Now, I think we're going to have to start seeing some legal cases relating to abuse. Another friend, her mother was being bullied by her cardiologist into agreeing. She adamantly refused. And the cardiologist's wife, who was also a cardiologist, then appeared in the ward and started to harass her to have the operation. That needed an application to the Health Rights Commission. Next. Now, before we finish, one of the things that I haven't gone through in sufficient detail, I think, is pain relief. No matter that we have spoken a little bit about it, let me tell you about a couple of cases that happened that I have recently heard about. One was a man who was admitted to a hospital in New South Wales. Both of these cases, the person had mild dementia. In the New South Wales case, he was admitted to hospital with a fractured hip, neck of femur, and it was a Friday afternoon, and his daughter asked for a palliative care consultation. And they had decided not to operate because he was too frail. But they weren't giving him adequate pain relief. And when she asked for the palliative care consultation, she was told there wouldn't be anybody there till Monday morning. Now, there would have been, it was a big hospital, at least someone on call. But despite the fact that they weren't giving him adequate pain relief, the nurses still came to roll him every 3 hours with his fractured hip. The first couple of times it happened, his screams drove his family out of the hospital, right out of the hospital. The third time, as the nurses approached, he looked at his daughter with terror in his eyes and said, "Not roll, not roll." His daughter sat on the side of the bed with her arms folded and said to the nurses, "To get to him, you're going to have to get past me, and I promise you, you won't." The next one was my own sister, who died in September 2012. And she had an advance directive. She had appointed a substitute decision maker. Her advance directive said she was to be given as much pain relief as she needed, even if it hastened death. But on the last day of her life, when she'd lost capacity, I'd been there most of the day, and her daughter, who was her substitute decision maker, phoned me not long after I got home, about 5 o'clock, and said, "Auntie Cole, I'm sure she's in pain, and I just spoke to a nurse and she said we gave her something 2 hours ago." I couldn't believe that they're still ordering pain relief every 4 hours for terminally ill patients. That is outrageous and very poor practice. So I said to my niece, "Not good enough. Are you up for another challenge?" And she said, "Yep." And I'd given her a few in the time that my sister had been there. So I said, "Okay, out to the desk, pretend you're me. Say to the nurse, 'My mother's in pain. That is unacceptable. Please have something done about it.'" And I told her to say it just like that. And she did. And the nurse went, "Oh, okay," turned to the man standing with his back to my niece and said, "Dr. X, could you please go and check Mrs. Garcia? Her daughter said she's in pain." He went in, he checked her, he checked the file, he upped her morphine, he upped her midazolam, and he said to the nurses, "She gets breakthrough medication every 5 minutes if she needs it." My sister died without pain, as she had an absolute right to do. So let me say that there is such a thing not only as healthy aging, but also healthy dying. And an aging world population brings many challenges, including the imperative to protect our most vulnerable people. And when all people, but especially older people, not only live well, but also die well, we can claim success. Thank you.
Well, thank you very much, Colleen. I'll now unmute everybody. So can you just make sure you don't make too much noise, don't rattle or anything like that, and we'll have a conversation. Okay, so everybody should be unmuted. I noted early on, Colleen, you made the comment that people had told you that you were doing this for your own purposes. Clearly, you're more doing it for your family's purposes at this point, so well done.
Thank you, Matthew.
I have a page of questions, but I'll be fair and open it up to the group first and see if anyone else wants to ask a question.
Could I ask a question, Matthew?
Yeah, of course.
It's Jane Mears, Colleen.
Yes, hi Jane.
Hi, how are you?
Well, thank you.
Recently, our beautiful friend and colleague Margaret Sargent died in February. She was sick for 2 months before. As you probably know, she belonged to Dying with Dignity, and she advocated very strongly for us to take control of the dying process, and that we of course, as you have rightly argued very, very well, you know, we have a right to control our dying. In the last months of her life, she was shuffled between Balmain Hospital. She ended up in residential care, and when she got there I think it was in February, she simply stopped eating. Of course, died not quite an unpleasant, in an unpleasant way, about a week later. What could she have done, or indeed some of us done, to enable her to die with dignity in the way that she wanted, not in this undignified? I mean, as you probably recall, Margaret was an incredibly determined person.
Sure.
And it certainly wouldn't be all of us who could starve ourselves to death, but that was what she did. But as I say, I would argue that was clearly not what she wanted, not what I would have wanted for her. What could we have done?
Okay. Firstly, if she was in her terminal phase, then it would surprise me that she suffered, because so clearly she wasn't quite at that stage. She wasn't quite at the stage where her body had shut down.
Right, that's correct. Yep.
Right, okay. In such a situation, I have to say that while euthanasia is illegal still, had she been in the community being cared for at home, she probably would have been able to find someone to help her with that. And I say that without any compunction, because I have a lot of evidence to prove it. However, I have spent 22 years staying neutral on the topic of whether we should have the right to assisted dying, mainly to ensure that the research that my colleagues and I have done had credibility. And every study that we have done, we have had people both strongly support and strongly do not support euthanasia being on our advisory committees and vetting every question we ask. At the very, very least, she could have requested terminal sedation if she was very distressed, and because terminal sedation is not just for someone whose pain can't be relieved, it's for someone whose suffering can't be relieved. And if her suffering was such that she was very distressed the whole time, then she could have requested terminal sedation. But as I say, in the community, just quickly on that one, a big study that I did in the Northern Territory some years ago, where we, while the Rights of the Terminally Ill Act was in place, I asked people to what extent you approve of the new legislation. And just two examples of 75% of the community strongly approved or approved, 50% of the nurses strongly approved or approved, and 33% of the doctors. But when I looked at some of the doctors who strongly disapproved, I found statements like, I'm not opposed to euthanasia, but I don't think we should hand such a can of worms to lawyers and bureaucrats. Another one who said, I've been helping my patients with this for years, but we don't need a law about it. They were not opposed to euthanasia. They were actively administering euthanasia, and so are many others. So I guess if you, of course, those people are putting themselves at risk. That's your only problem.
That's a really helpful answer. And I think the other part of that story is the distinction you made at the very beginning between euthanasia and end of life. And I mean, we obviously need to keep that in mind too. I think in Margaret's case, she was aware that if she could get home, she could do it. She could think he'd be able to pull it off in the nursing home, in residential care. So that's a really useful answer, Colleen. And I think it's one that we all need to take on board and remember. I mean, as you say, we don't want to be caught up in that debate around euthanasia and all the emotional and silly arguments that come to the fore. We want it to be a debate about dying with dignity and end of life. Thank you very, very much.
And
And it was a great presentation, by the way. Thank
Well,
you.
Thank you. But just one quick thing on that last one too, silly arguments. There are very good arguments on both sides, but just recently, Margaret Somerville, who generally is reasonably balanced, but every so often on this, I mean on other ethical issues, but on this topic goes right off the line, talks about the Nazis. Now, if anyone ever uses that argument to you, any of you, in relation to euthanasia, you know they've lost the plot.
Yes.
Because what the Nazis did had absolutely nothing whatsoever to do with euthanasia, which is a good or peaceful death. It was genocide and murder. And anyone who tries to compare what's happening, for example, in the Netherlands, where I've done quite a bit of research, with that is not only being ingenuous, it says they don't have very good arguments. Anyway, next question.
Thank you very much, Colleen.
Can I jump in with the question,
Go for it.
Colleen? Thank you so much. I've also got a whole page. I was just going to say, it seems like you're sort of rolling the dice with professionals, like seeing who you're going to get when you're dying. Have you done any research into why professionals do want to extend life when it's clearly not the best for the patient's well-being at all, like those two cardiologists you were referring to?
Well, unfortunately, in their case, and I'm sorry to say this, Susan, because I can't prove it, I truly believe that it was a financial situation. Specialists get paid for interventions. They don't get paid for just, making sure someone's well cared for. And that's probably a harsh thing to say, but I could see no other reason in her case why they couldn't accept her decision. It is a roll of the dice, and I've said to many people that the whole issue of euthanasia, for example, has come down for me to a social justice issue, because if, for example, I wanted it, I would know who to ask and how to ask. If you're well educated and well heeled, there's a fair chance you'll know, or will know someone who will know. And why should I have access to something that the rest of the community doesn't have? However, as I said, there are good arguments both sides. The same with the mini mental state exam. For somebody saying that you don't have capacity, I had a group of older people who contacted me and said, well, what can we do about that? If they're going to use a faulty tool, my argument was, if they're going to use a faulty tool, I'm going to be an anarchist and help you subvert that tool. So I gave them the list of questions and the list of answers and told them to rehearse and rehearse and rehearse, so that they wouldn't be deprived of their rights to make their own decisions on the basis of a faulty tool. But yes, it is a throw of the dice. Maybe you need to start asking your healthcare providers well in advance about their attitude to things, and make sure you're comfortable with their attitude. And I'm not suggesting that people have to provide euthanasia, because it's ethically justifiable to take your own well-being into account. I can give you the ethical basis for that if we need to. You don't have to break the law. The other thing is that a lot of the older doctors are still, I think, hooked up a little bit to the Hippocratic Oath. Now, the Hippocratic Oath, which doctors don't take anymore, and it's not even read out anymore, I don't think, at medical graduations, used to say, I shall never give anyone a lethal substance. However, it also used to say, no doctor should ever perform surgery. That's the job of the barbers. It also used to say, don't tell your patient what's wrong with them. So you can see how the Hippocratic Oath has kind of gone out of being relevant a long, long time ago.
I assume some religions have quite an influence on how professionals function. Yes,
they do. Interestingly enough, in our research, as you would expect, the second highest anti-euthanasia is the Catholic Church. The first is quite a number of the other fundamental religions. But some religious groups like Uniting Church and others are not opposed to it at all, or some people are, but possibly not because of their religious beliefs. Yeah.
Thank you.
That's okay. Next.
I'll just make a comment, Colleen. Is it evidence of capacity that you can actually memorise the responses for the mini-state examination? I would struggle to remember the responses.
Well, Matthew, you might not if, for example, if it's your short-term memory that's gone and you spend 6 months now in a group quizzing each other on the responses, and that gets set into your brain, then you might actually, and I want people to be appropriately assessed if they have lost capacity. But I've seen people, one woman who was assessed as having, she could draw the pentagon or whatever it was that you are asked to draw in that. She used to be a dressmaker. She could probably draw it, with her eyes shut. There are better tools. The GP cog is a better tool. There are better tools, and the New South Wales capacity assessment handbook is excellent and doesn't even mention the MMSE.
Okay. Further questions, or I'll start asking them, and you don't want that?
Hello, I've got a comment. Sarah's my name, Sarah Carasoni, from the University of Western Sydney. Just in the scenario that Jane was talking about before, it's just a sort of a general overview, because I see it quite a bit in my work, where it's a little bit off topic, but where someone's really loses their ability to make a decision because circumstances are kind of against them. So in that scenario where your friend ended up in residential aged care, whether she wanted to go there or not, probably not, because there's nobody home. And it's really awful watching someone kind of being forced into that decision because there's just nothing to do about it, and I think that's such a source of suffering initially, around that point of decision, and realizing that that older person has lost the battle, even for the health professional watching that, So I think whilst we talk a lot about decision-making capacity, just sometimes there are opposing forces, and that's just social trends and whatever else is there.
That's a very good statement and comment, and thank you for that, because I do feel a lot for our health professionals as well, particularly in situations where they are under scrutiny. In that situation, they're not going to be able to assist the person to have the death that she wants. About the best that they could do would be, as I said, to request terminal sedation for the person if that's the person wants, if they discuss it with them and giving them that option. But yeah. So is that Matthew asking me a question now?
A different Matthew, I think.
Different Matthew, yes. Do you have a question for me, Matthew?
Yeah, I'm a nursing student at the University of Canberra, and I was just sort of picking up on some of the things you were saying about healthcare professionals and leading it back to a comment you made earlier about advocating for the patient. What sort of advice would you have for a healthcare professional to get the best outcome for a patient who's dying?
Actually, I sometimes tell nurses, if they're concerned that the medical practitioner may not listen to the patient or to them, that they could use the approach of, "Doctor, I'm really worried about you," or "worried for you." What, for me? Yes, because as you would know, I'm sure, Doctor, advance directives are legally binding.
Yep.
And so are the decisions of the substitute decision maker. And Professor Cartwright said, we're going to have some legal cases in this country very soon, just as they have in the United States. And I'd hate to see you be the first case,
yep.
Says I with tongue in cheek. But and there have been, pain relief is the one for which there have been the most cases in the US, where doctors, nurses, hospitals and nursing homes have all been successfully sued for inadequate pain relief in terminal illness. It's a human rights abuse, bottom line, end of story. But if health professionals are not listening, then maybe families need to be assisted to understand the legal rights of the person.
Yep.
Now, I know that in hospitals, no matter what they say, nurses are in a one-down position in terms of power to the medical practitioners, and that can be very challenging. And you could be concerned about losing your job or whatever. But you could actually ask, if you're in a major hospital, is it possible to speak to someone on the ethics committee because of your concerns about what's happening? But even advocating for the patient, I mean, families can do it, as I did. The second day that my sister was in hospital, when she still had capacity, I went out to the desk after speaking to her and asked the nurse, how do we organise a palliative care consultation for my sister? And very dismissively, without even lifting her head from what she was writing, she said, oh no, that's up to the treating team to organise that. I said, excuse me. She looked up and I said, how do we get the treating team to organise a palliative care consultation for my sister? Oh, she said, I'll make sure they do. And a palliative care specialist came the next day. But it wouldn't have happened if my sister hadn't had a fairly bolshy advocate.
Yep. Thank you for that.
Pleasure.
I've got a question, Colleen, that's come from a lot of the discussion about the challenges faced by the health service. You gave an example of a PEG example of a husband who had insisted on, I think she'd been in a vegetative state for 10 years. What could the service have done to actually prevent that going for as long as it did?
Yes, I mean, it should, whenever invasive technology is being considered, Matthew, the same question should be asked at the beginning and throughout. The first question is, what's our goal of care for this person?
Yep.
Is our goal of care curative? Is it palliative? What's our goal of care? Is it comfort care only? Will this treatment help us to reach that goal of care? If it clearly will, with consent of the person or their substitute decision maker, then you start it. If it clearly won't, then you don't even offer it, because no doctor is obliged to provide futile treatment. If the family says, why are you not doing X? Then you try to explain that I'm not doing it because it will not offer your loved one anything of value. And particularly if the person has already lost capacity. If they haven't, then it shouldn't be up to the family anyway, it should be up to them. But you'll often find families trying to overrule the person and insist that they receive treatment. But if you start the treatment, then you still should be asking the same question at very regular intervals. Is this treatment continuing to meet our goal of care? And if it's not, then it's time to withdraw it. And you'll often find that people are much more willing to withhold treatment at the beginning than to withdraw it once it's started.
Yeah.
And they have that fear that I spoke about earlier in the presentation, that it's some form of euthanasia to withdraw the treatment, when it absolutely is not any form of euthanasia. But sometimes it does take a lot of work, and sometimes it's how you present it. You know, you hear the numbskulls who say to families at a crisis point, do you want everything done? Well, of course they're going to say yes. They'd feel guilty forever after if they didn't. But one of my palliative care colleagues, when she talks to people, she'll say something like, I realise you're grieving and you don't want your mum to die, but she is going to die soon. What I need you to help me understand, this is in relation to continuing invasive treatment. What I need you to help me understand is why you're asking us to prolong her dying. And in most cases, the family will say, oh no, we don't want you to prolong her dying, but that's what you'd be doing if we continue with this treatment. We're not prolonging her life, we're prolonging her dying. On other occasions, when I asked her how she has her CPR discussion or no CPR discussion, and she says, I just say things to them like, your mum's entering her dying phase now, and it's possible she'll just go off to sleep and won't wake up, and wouldn't that be nice? And they say, oh, that'd be wonderful. And that's just what she would want. And my friend said, I've just had my CPR discussion with that family.
Yep.
Wow.
It's useful, isn't it?
It is.
Yeah.
Okay, further questions?
Matthew, if anyone does have any further questions that they think about after, please feel free to give them my email address.
Will do.
And they can email me. Or if a case comes up, I'm happy to be a resource, not for ongoing or lots and lots of stuff, because that's my whole consultancy company. I provide advice and all of that on a consultancy basis. But if you've got a tricky case on your ward or something, and you just go, oh, Colleen, what's the situation here? Just email me.
And as you said earlier, Colleen, you have a massive number of resources on your website freely available for people to download.
Yep.
You've collected from across the country, so that's a really brilliant resource.
Yeah. So if you want to just type Cartwright Consulting Australia into Google, the first thing that comes up should take you through. And if you click on resources, there's lots of documents and research reports and all sorts of other stuff.
And it's on your last slide that everybody got as well.
Oh, good. Oh, there you go, Matthew.
Just another one, an odd one that occurred to me was you gave the example of the next door neighbour was designated as the carer because they'd been literally looking after the person every day. How did they substantiate that claim? What's required to prove that sort of status?
Well, I guess the community nurses would have seen it.
Okay.
I guess the GP would have known if she was taking the person to the doctor. And, you know, the family, I don't know if they even lived in the same location.
Yep.
And if the person had entered her terminal phase at home, then clearly somebody had been caring for her. Onus of proof, I guess, the same with the res care facility. If you get families, if the person hasn't had a carer, and then I don't know if I made it clear, if someone has a sudden heart attack or stroke or whatever, injured in a car accident, then it moves to close relative or friend, and at that point you could have half a dozen people having a Barney over the bed.
Yep.
So folks, don't risk it for yourselves, for starters. Make sure you've appointed your own substitute decision maker. But help your clients with that as well, and they'll usually be able to. And if they say to you, "Oh, I have to appoint both my son and my daughter, otherwise the other one will get upset,"
Yeah.
I always say to them, "Do they get on?" "Oh no, they hate each other."
Yeah.
And don't bother; it's still going to end up in the tribunal.
Yeah.
Only appoint people jointly if you know they get on.
Yep. Good point. Opposite side of the same question, there's another peg example. You said that the husband applied to be the guardian but wasn't actually appointed. It went to the public one. On what basis would that have been made?
Oh, that was because it had hit the newspapers, Matthew, and the publicity around it was enormous. And poor Julian Gardner, you know Julian, who public advocate at the time for Victoria, I think, he got all the sticky ones. He got the Maria Corp case as well. And it was just that you had Philip Nitschke on one side and Margaret Todd from Right to Life yelling and screaming, one of them saying, you know, that removing artificial nutrition hydration was euthanasia, and the other one saying, if you're going to remove it, that means she's going to take a while to die, so you should provide her with euthanasia anyway. And it was such a contentious issue that the guardianship tribunal decided that it would have been, the husband would have been at risk if he'd been appointed.
No, wonderful. Good. All right. Are there any other questions? Well, look, I think that was an outstanding session. As I say, it's taken a few years. It was worth the wait.
Thank you, Matthew.
That was brilliant. So we will circulate the recording. I remembered to press the button this time. I didn't remember last time. So we'll send it around. I've already had email feedback from people saying how much that they appreciated the session. So thank you so much. Thank you, everybody, for participating. And don't forget the virtual seminar in October. We'll send the details around on program evaluation, the upcoming workshop in front of the AAG, our ERA conference, and the ERA travel grants. Make Sue's work hard and give her more applications to go through.
Yeah.
Thanks, everyone. Thanks, Sue, for your help.
Thanks, Colleen. That was so good.
Great.
Bye.
Thanks.